Hey everybody, Harry here to talk about the just completed hearing in Fulton County, Georgia on the topic of whether to release to the public the report of the special grand jury that's been working for many months to decide whether to recommend an indictment of Donald Trump and others. To cut to the headline and the bottom line, the judge decided that he hasn't decided yet, and that one, he won't do it rashly, that is, not immediately and not abruptly. He will rather give the parties some warning, and us as well, so that they can run up to the Court of Appeals to prevent his decision from taking effect. Okay, so the immediate bottom line to be aware of: no report coming out right away, and no report coming out without some warning. All right, now let's double back. So remember, this is the case out of Georgia that's always seemed to me to be really the probably most direct and quickest threat to Trump. It involves different efforts on his part, Giuliani's part, others, to monkey with the election. The centerpiece of the evidence is the audio tape of his browbeating call to the Georgia Secretary of State, Brad Raffensperger, saying, "I just need 11,780 votes." Okay, those are the potential crimes in issue, and they would be under Georgia law, and there would be 3 or 4 that seem to be in play that basically have to do with fraud on the election. All right. The DA of Fulton County, Fani Willis, asked for this special grand jury back last April, I believe, concerned about certain efforts by the possible suspects to resist things. The special grand jury had a little bit more power to investigate on the one hand. On the other hand, it cannot issue indictments. So now that their report is completed, the DA can convene, or there is in fact a sitting grand jury. In fact, they're sitting today in that courthouse, but they're the ones who would have to charge and recommend an indictment. And the process would be for the DA to re-educate that grand jury. You could just bring in an agent. You don't have to go through the whole proceedings again, but just to summarize what's there and ask them to return an indictment. Hey everyone, we're taking a quick break to ask you to take a second to like and subscribe. It's a quick thing that really helps the show. Thanks, and back to the video. All right. The grand jury goes for many months, hears from a lot of people. We've had different skirmishes along the way. Giuliani having to testify, Senator Lindsey Graham, who also tried to browbeat the Georgia Secretary of State and maybe in some jeopardy here, having to testify. Many witnesses, a very thorough job. And significantly, it seems to me, the special grand jury, when it completed its work, said, "We want to publish this." What's special to that is it just, to me, made it seem much more likely that they were recommending indictments. Why else would they say, "We want to publish it"? All right, so it's turned over, this odd report from an unusual kind of entity, a special grand jury that can't give indictments. It's turned over to the DA and the court, and now the question is, should it be published right away? That's what the hearing was about today, and it was between just 2 parties. Nobody, for Trump, for instance, said, I have nothing to say. I assume they're going to exonerate me and just try to play it insouciant. Okay, so the parties were the DA on the one hand and a bunch of media folks on the other. And the Judge McBurney, the presiding judge there, who I thought was very sort of thoughtful, even-tempered, impressive. The DA's position was, don't release it now. Why not? Well, it could potentially harm defendants. How would that be? Say the special grand jury says, indict Giuliani, and the DA decides not to. Well, that's now been public, and Rudy Giuliani has been prejudiced. Or there are similar kinds of concerns involving witnesses, say. And the media said, no, 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 no. This has now crossed the line where it's been delivered to the court. It's a document in the court system, and there's a strong presumption in favor of publishing documents like that unless certain very unusual and important counterpoints are present, and here they are not present. Now, the judge had initially indicated maybe there would be a couple provisions of Georgia law, either the definition of a legal term, presentment, general presentment versus report, or there is both a provision that says if the grand jury requests it, and you must release it unless certain things are present. And I don't think we need to labor too much with those specific rules and how they cut under Georgia precedent, because both parties were pretty quick to say it's an unusual situation, not directly covered by any previous cases on point. So the DA got up and made a pretty kind of mealy and wandering presentation, saying there could be this, there could be that, and we, the DA, we need some time to sort of get our act together and decide how we're going to use that report. And so you'll release it eventually, Judge, but not right away. Some things have to happen. So their position was for delay. And there had been some thought when we found out the special grand jury was finished that today the DA would be sort of ready to go, take it to a grand jury, which is sitting today, announce charges, because you don't want that kind of document out there with all these thoughts and theories, etc., and just to educate defendants. That you would want to go quickly and bring your own charges. But it seems to me a fair inference that the DA is not ready today or tomorrow or next Monday to bring the case, is still doing some kind of crossing of T's and dotting of I's. So they don't want it out right now, and that was their position. And they gave kind of, a grab bag of concerns, for instance, how it could hurt defendants. The media's position was much crisper. It was, look, there's a presumption in favor of publication, and come on, public interest here is overwhelming. You have to do this, Judge. And the kinds of considerations that they're talking about, they're present in all kinds of situations and documents, and it doesn't prevent the court from ordering a record to be made public. So you have to do it, and have to do it, he was saying right away. All right, so that's what the judge was taking account of and trying to indicate there are many different things to balance. And at the end, after both presentations, the judge addressed the parties and said, all right, I'm not going to do this in a rash way. I want to look at certain arguments I hadn't really thought about before. And, it suggested it hadn't started to write, hadn't made a tentative decision. So it was just going to go and sort of from scratch put this together. And it is a difficult question. So that process alone seems to me to be several days, a week at a bare minimum. Moreover, the judge then said, and I won't release it. I'll tell you what my decision is to release it, so you guys can run to the Court of Appeal and try your luck there and maybe countermand me before it's even out. So all this basically made it seem like, you'd really have to do some guesswork with the way this judge works and the court system works, but 1, 2, 3 weeks anyway, just for his process. Now notice, though, that's in essence giving the DA what they're asking for. You have to imagine after a few weeks, they may now be ready to go. So it's a de facto victory for the DA. Will the media defendants come back in and say that and say, look, this is getting a little moldy and the public is really demanding now you need to try to decide it more quickly? That kind of motion's very hard to bring to a judge. Do it now rather than later, or even more extreme, tell a court of appeals to order the judge to do it now. That sort of order can happen, but only when a judge has had extraordinary delay. So I think even though, as I sat there, the basic submission of the media the media responders seemed stronger, that there's really nothing enough special to distinguish this, and the judge should release it. It seemed that the way the process was going to go and the judge's own sort of indecision, though he seems a thorough and deliberate judge, not a, that he's trying to avoid making the decision, but that would in effect work to the DA's benefit and give the DA what she's looking for just while the court's in the process of deciding. Maybe not. The court could do it more quickly and along sort of clean lines and principles that the media defendants served up to him, but it looked like that's the way it was going. Okay, so we're going to be following closely, of course, because we may learn, it's about to issue, or there'll be some timing. We won't have to, wake up with the house on fire. We'll know that a tentative decision has been reached and it's going up to the Court of Appeal. So when that happens, I'll be back to talk about it. Until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.